Welcome to the Benson Wealth Podcast. I take complex financial and economic topics and make it accessible to the everyday listener. Hello, everyone, and welcome back to the Benson Wealth Podcast. My name is Drew Benson. I'm the president and founder of Benson Wealth Management and a senior wealth advisor with Raymond James. I'm also the co-managing partner for True North Wealth Management Group, which is a platform for independent wealth advisors. I'm a former macroeconomist, and I'm currently a certified financial planner and wealth advisor. So today I interview repeat guest Leslie Madge. Leslie is a longtime friend, and she's practiced estate planning law in the state of Massachusetts for many decades. Today we're going to talk about two important subjects. The first is we're going to talk about estate tax considerations, and we're also going to talk about who you should potentially consider naming as a trustee of your trust, and should it be your children. I hope you enjoy the podcast. Leslie, welcome back to the Benson Wealth Podcast. Great to see you.
Drew, again, it's so much fun to be with you. Thanks for the invite.
You're very welcome. So let's dig in today. Today we're going to talk about a couple subjects. We're first going to discuss estate taxes. So let's first talk about who will actually be eligible, those lucky people that will be eligible to pay federal estate taxes. So by the way, at the federal level, estate taxes for this is 2024. So for this year, the estate tax exemption, the lifetime exemption is $13.61 million per person. Now, one of the questions that I receive a lot, Leslie, is say that someone would like to gift money to a child. So let's say it's over. By the way, there's an annual exclusion amount of $18,000, so you can give that away free and clear. But there's oftentimes, and I received this question actually a couple weeks ago, a mother is trying to gift money to a family member, and they wanted to know, hey, if I give over $18,000, am I now going to pay federal estate taxes? So what say you, Leslie? Will they have to pay estate taxes?
So that's an excellent question. I would get it a lot as well. And my short answer is you're worried about the wrong problem. The longer answer is when you make a gift greater than the annual gift tax exclusion, which, as you say, is $18,000 this year. So let's say you want to give away $118,000. The first $18,000 is federal tax-free. The second $100,000 is subject to tax, but you don't actually pay a tax. What you do is you file a gift tax return, and the gift tax return says that your tentative tax is such and such. I'm going to make up a number, $20,000, just to make up a number. Sure. You don't stroke a check for $20,000. You walk over to your pile of tax credits, which equals $13.6 million. So you take enough credits out of there to pay the $20,000 bill, and then you have no tax due. Now, when you die later on, instead of being able to leave $13,600,000 tax-free, if you use $20,000 to make a gift, you can leave $13,500,090 tax-free instead. So you use $20,000 of it. I think you think the math is wrong. I rounded my numbers. So $13,600,000 minus 20 would be $13,580,090, whatever. Mine, I can't do this in my head.
I get your point.
My point is that unless you are already flirting with your net worth hitting the limit of $13,600,000, which for my clients is not true, and for the vast majority of people, their net worth is going to be comfortably under that number, they're not going to have an estate tax. And if they're not going to have an estate tax, the fact that some of their tax-free amount was used up during their lifetime to make a gift will have no effect. So the short answer is there's no tax problem because your total net worth is under the federal limit of $13 million, whether you give it away during life or whether you leave it at your death. But there is a different problem, and this is why I say you're worried about the wrong problem. So when you give away $118,000 in that example, or when you give away $18,000, it doesn't matter whether it's over or under the tax-free limit. If going forward for the following 5 years, you or your spouse has a serious medical event that results in the need to have placement in a long-term care facility, for which you will have to pay privately to the tune of $10,000 to $18,000 a month, depending upon which state you live in. Once you run out of money, then the state Medicaid program will take over. Well, they're going to look back, when you apply for assistance, they're going to look backwards 5 years to see what you did with your stuff. And if they see that a year ago you gave away $118,000, or you gave away $18,000, which you're allowed to under the code, they're going to say, we are not going to approve you for Medicaid because you gave stuff away. There is a 5-year look back, and the fact that you made these gifts with no intention of going to the nursing home, you're trying to help your kid, you're trying to do whatever, the fact that within the 5 years you had a medical event changes all the rules, and you will be punished retroactively by virtue of having given that money away. So my answer is, you are worried about the wrong problem. For the vast majority of people, they are never going to have a federal estate tax problem, and therefore giving money away greater than the annual $18,000 exclusion is no tax problem. But giving anything away is a problem for 5 years going forward if you or your spouse needs long-term care and you want Medicaid to step in and pay the bill. That's going to affect everyone when the tax problem affects almost no one.
So I have 2 follow-up questions on that. So let's say you just give $18,000 to, Billy, your son.
Yep.
So if you do just the annual exclusion, is that exempt when it comes to Medicaid, or is it any dollar amount that they're going to consider?
It is not exempt, and that's what I was trying to illustrate in saying it doesn't matter whether it's $118,000 you give away or $18,000 you give away. So then, if in all other respects you're eligible for Medicaid because you've used up your money, and the only problem is this $18,000 you gave to Billy last year, well, you have to cure the transfer. And the way you do that is you go to Billy and you have him give it back. Good luck with that.
What if Billy spent the money, was my next question.
Exactly. So you will not be able to cure the transfer. Now, if some other relative wants to come forward and out of the generosity of their heart give you the $18,000 back, that would work. Medicaid doesn't care what the source of the money is that's so-called curing the transfer. But the odds of getting someone to pony up that kind of money without having been involved in the first place are slim to none. So if you are unable to cure the transfer, then Medicaid is going to deny you unless you can make a convincing hardship case, which is very much case by case, examiner by examiner, state by state. They don't have to, and it's pretty rare that they do.
So Medicaid's a federal program, but it's administered at the state level, correct?
That is correct, and the states participate financially as well. It's a 50-50 funding source. So because the states pony up 50% and then get 50% from the feds to make the program work, not only are there federal rules, the states add a spin on those rules so that each state's interpretation within parameters can vary, and what might fly in state X might not work in state Y.
But the 5-year look back is true in all 50 states, correct?
At least 49 of those states. I haven't checked lately, but the last time I checked a couple years ago, California was still 36 months.
Okay, interesting. So just 3 years. So let's talk about it. Anything else you want to touch on that? And then I would ask about filing Form 706 and why that matters. So
I would say that people can feel comfortable with the gifting tax problem. Most people now, if you're over $10 million in assets, this is not for you. Now we need to really have a tax conversation. But for the vast majority of people, the tax problems of gifting money or assets is not the problem. It's the potential Medicaid eligibility problem. And as you get older, this is going to be an increasing risk. And 5 years going forward is a long time, but looking backwards 5 years is the blink of an eye. Think about, it feels like yesterday you were 5 years younger, and yet thinking in advance 5 years going forward, that's a lot longer period of time, and a lot can happen in 5 years. So you could feel totally hale and healthy and it's all good, but things can happen, and you should carefully consult with your financial and legal advisors to prepare a contingency plan if you're determined to go forward with the gifting.
Yeah, and as tough as this is, particularly for clients that are, say, in their late 60s, getting into their 70s, I've seen, sadly, way too many clients that were very healthy, 100% cogent, and then within a couple of years, a severe illness such as Alzheimer's or other physical ailments set in, and their life has changed really, frankly, on a dime. And so I think this is a very important consideration because, unfortunately, Leslie, you and I have witnessed this way too many times, more than we would wish to. So let's talk about filing Form 706. So
sure.
One of the things that occurs, so let's talk about people that have a little bit more significant wealth. So some of my higher net wealth individuals and folks that maybe you've consulted over the years. So there's this thing called portability, right? So each spouse at the federal level is given this lifetime exemption amount of $13.61 million. So that means spouse A. So we'll say Billy and Susie. So Billy gets 13.61, and so does Susie. So they're given quite the pretty penny. That's over $27 million, right, of estate tax exemption. But it's not automatic. So explain portability, and then I want to talk about who should consider filing Form 706. So what is portability, Leslie?
So first of all, Form 706 is the income, it's not an income, is a tax form that is filed with the Department of Revenue, the Internal Revenue Service, to satisfy any estate tax obligations that are due on the death of a person. Each person, married or single, is allowed a tax-free amount called the exemption equivalent, or they change the terminology all the time. This year is $13.6 million. When they first started raising the limit, back in 2011, they invented a new concept called portability. Because here's what used to happen federally, and here's what still happens in a number of states, including Massachusetts.
Correct.
I forgot the name of your client. My fake clients are always John and Mary. So if you don't mind,
let's go to John and Mary. Forget
John and
Billy
Mary.
And Susie. We don't like Billy and Susie anymore. So John and Mary.
John and Mary, and they have everything owned joint, which is often the case. And even if it's not joint, John and Mary are going to leave everything to each other. So pick one. John dies. Everything is going to Mary, one way or another. And they're worth... It doesn't matter what they're worth. They're worth $1 trillion, $20 million, $50 million. John dies owning $50 million, and he leaves it all to Mary. That's over the $13.6 million, isn't it?
That's correct.
But there's no tax due because Mary, as the surviving spouse and a U.S. citizen, if she's not a citizen, this doesn't apply. It qualifies for something called the marital deduction that says 100% of what goes to the spouse goes tax-free. So Mary gets the entire $50 million tax-free. Now she carries on and she lives her life and it's all good, and down the road then she dies. Now she dies owning the $50 million that she got from John, and let's say she had $20 million of her own. So now she's up to 70 million. I can't do math today. $70 million. That's over the 13.6, which she is allowed to leave tax-free, and she will pay a tax on the entire amount. Let's make more realistic numbers. John and Mary have $15 million. And John, and he has $16 million. John has $8 million and Mary has $8 million. John dies first. He leaves his entire $8 million to Mary. It's not taxed, not because it's under the $13 million, but because she qualifies for the marital deduction. So now she has the entire $16 million. When she dies later on, and she dies, her estate is valued at $16 million. She had $8 million. She inherited $8 million from John. That's over the 13.6. She will pay a tax. And the problem is that we never got to use John's tax-free amount because he left it to the one person on the planet who was exempted from that rule. So this is where the legal industry created a whole structure of trusts that you still need to use at the state level. But at the federal level, because of portability, if you do it right, you don't need it. So let's rewind the scenario. John dies. He leaves the $8 million to Mary. There's going to be no tax because of the marital deduction, so why do we even need to file a return? Because if we file the return to show the IRS there's no tax due because of the marital deduction, we're not using any of his lifetime credit of $13.6 million, but we want it, please. So we elect the option to port the unused amount, which in this example is 100%, to port the unused amount over to the inheritor, Mary, and she will now have a tax-free amount of $13 million of her own and $13 million that ported over from John. She can leave $26 million. So now when she dies, owning that same $16 million, well, that's over her 13, it's under their combined 26 and it becomes tax-free. But you have to elect it on a federal estate tax return. And so many people think when someone dies, oh, they were way under 13 million, I don't have to file. You want to consider filing to preserve the portability for future use in case you need it.
So what is the time frame, by the way? There's a limit and with which you can actually go and file Form 706 and apply for portability. What is the time horizon after a spouse dies?
The time frame is 9 months from date of death. It is not subject to extension. So I've always thought it was interesting. They give you 9 months to get here and then 9 months to leave.
It's great. So I've had a few scenarios over the years where at the time of spouse A, so John dying first and Mary's left behind, they're not necessarily all that close to the full exemption amount for both couples. But assuming that, say, Mary lives a long time, when you start to do math on it, when I run financial plans for clients, I'll notice that, hey, there is this, it's conceivable if markets perform really well that you could get over that 27 million mark. What do you say to people that it's like, hey, you're kind of on the edge. Is it worth just going and filing the form? Is it that much of a headache?
That's a great question. And the decision on whether to file to preserve portability is very much a case-by-case decision and should be made in conjunction with financial planning and legal advice. If you're dealing with an older surviving spouse who is not in an industry that's financially volatile, if it's Elon Musk and he loses everything tomorrow, he might do it again and then suddenly be worth trillions of dollars again. That's the nature of that entrepreneur. But for the average person, as you get older, your financial situation is largely stable. It might decline some. It might increase some, but not dramatically. So for that person, I might say, if you're comfortably under the 13 million threshold, don't bother. But if you're younger, even if you're under that threshold, there's a lot of life in front of you. You could win the lottery. You could inherit. You could start a business and cash out. There are a lot of things that could change in your life that would suddenly catapult you into a different tax bracket. It's a very small thing to file an estate tax return and for the sole purpose of electing the portability. You want to hire a professional to file the return, but it's not a really expensive proposition.
And just to be undeniably clear, though, let's say that John dies today and Mary lives 20 more years. They get above, let's say their life ends and Mary hit the jackpot and now she's worth $35 million. She can't go back, right?
You cannot. Well,
you got 9 months.
First of all, you would be talking about amending his return, and you're well outside the statute of limitations to amend the return. But even if you were inside the time frame to amend a return, you can't amend it for this purpose. Your eligibility to elect portability is 9 months hard, not subject to extension, not subject to going back and amending. You have to do it within the 9 months.
So, my word of advice or wisdom to anyone listening is if there's any chance that you might be over there, if there's a strong proposition that you're over it, this is something you want to seriously consider because you just can't turn the clock back.
That's right.
So you might as well file Form 706 and
It's
elect
a small
portability.
extra step to preserve a big benefit going forward.
So this is great, and I appreciate the insight on estate tax considerations. There's always been a fair bit of confusion with clients over the years, so I appreciate the clarity on this. Let's talk about one of my favorite subjects and probably one of your favorite subjects, and that's who do you name as the trustee of your trust? So there's a lot of different people that you can consider, Leslie, when you design a revocable trust or maybe an irrevocable trust. Oftentimes, what I see most individuals doing is they name a child. So, and I do want to stress, like, we're not making blanket recommendations here. Obviously, work with a actual attorney and an advisor to help you come up with a proper strategy. But generally speaking, what has been your experience when people name children as trustees of their trust, Leslie? And what is your thought on that?
So first, let me just say that the stereotypical traditional view of a trustee is you have a trust and generally a corporate, usually like a bank or an institution, is the trustee. And they have gotten a really bad rep, largely deservedly, because their fees are very high and their attention to investing is low because you're a captive audience. So you can't go away if you're not happy with the performance. You'd have to go through a very complex petition to remove a trustee for failure to do their job. And the standard to prove that is very high. People don't do that. So they live with the unnecessarily low rate of return because they're stuck with this trustee. Whereas if the bank was not the trustee, then they could pick up their marbles and go somewhere else if they're not happy with the investment. So you have high fees and mediocre performance. Also, corporate or institutional trustees only want net worth individuals north of a number, and it's usually north of several $1,000,000, and they want it in liquid cash. They do not want trust investments that are illiquid, like real estate or types of investment trusts that you might be able to be involved in. So it limits the pool of trustees because you're not in the market. Either they don't want you or you don't want them. So who do you turn to instead? For many estate planning purposes, you're doing trusts either to save the kind of taxes I just described that we avoid at the federal level with portability, but portability is a federal invention. Many states have not adopted it. Massachusetts, my state, has not adopted it. So if you don't put the proper trusts in place, you're not going to get the benefit of the first guy's unused tax-free amount. So you do it for tax purposes, you do it to avoid probate, you do trust to save assets from potential nursing home. There are lots of reasons to have a trust. When you have a trust, you need a trustee. And the trustee is going to end up being someone other than you. So if it's not going to be a bank, who is it going to be? So let's assume that you did, a trust to save assets from the nursing home, let's say. And I did lots of those. And they would look around and they would settle on a kid. And here's the problem. Well, there are lots of problems, but one that I try to impress upon clients, and I will be honest and say I have fair, not better than fair success with this, is so you got John and Mary. They come in, they want to save their assets from the nursing home. They're willing to do the trust. They've got 3 children, Tom, Dick, and Harry. So the trust is going to run and for the lives of John and Mary, and on the death of John and Mary, it goes out to Tom, Dick, and Harry. Who's going to be that trustee? So they pick Tom. Tom is there, and yes, I want to do everything that's right for mom and dad, and we're going to live our best lives, and we're all in front of what's best for mom and dad. And they mean it, and it's true. Here's the problem. Even if it is true, and there are many times when it's not true, and kids come in with their own agendas. So let's just follow the trail here. Life goes on. John or Mary dies. Let's pick Mary. Mary dies. The trust keeps going. And maybe Mary was in the nursing home and it all worked. And we're so happy. We saved all these assets. And then Mary dies. But we're still running the trust because John is around. I picked John because I'm going to be sexist here. John is living his life, but he doesn't like Mary not being around. And he decides to start putting his toe in the dating pool again. And he starts meeting up with lovely ladies, and he either is living his best life or decides to marry Janie, and the kids are not so happy with this.
We don't like Janie.
First of all, Janie is taking Mary's place. They don't like that. Let's get past that. A lot of kids can. But especially if John marries Janie, well, now you've got this Janie come lately in the picture, and now they're wanting to spend the money that's in the trust, and there are ways to do that. You build mechanisms into the trust to be able to get at money, which works when all the parties are on board and rowing the boat in the same direction. But when the trustee and the kids start to not like the disposition of what they're hardeningly thinking in their mind without even saying it, this is my inheritance. I don't want to be spending my inheritance that I'm entitled to. No one's entitled to an inheritance, but they start to feel that way, whether they express it or not. And even without a Janie come lately in the picture, over time, kids start to have an entitlement mentality when it comes to this money, and it hardens faster when there's a Janie or a Joey come lately into the picture. And it starts to create tremendous divisiveness within the family that could go as far as leading to estrangement. Dad doesn't like the way Tom is managing the trust anymore. He wants to get rid of him. It's not that easy. First of all, many trusts that I've seen written by other lawyers don't have proper language in it for scenarios like this. And then you have to go to court. And it's horrible and expensive, and the only winners in that are the lawyers. If it's properly drafted, there'll be mechanism to change a trustee. It's still not an easy process, and it's still going to be subject to litigation, and it just does not work well. You can avoid these problems if you have an independent trustee out of the gate. He has no dog in this fight. So as the surviving spouse is going on and living his or her best life and wanting or needing to access these funds with the proper language in the trust to make it possible, the trustee can be distributing funds in an appropriate way without this problem hardening within the family of who has rights and whose money is it and who has a say over how the money is being spent. I don't like that Dad is going to go buy a Corvette. I think a minivan is good enough, and I'm not going to agree with that. This is lifestyle decisions which are impacting the familial relationship because the children are acting in a fiduciary role. You're crossing boundaries and blurring lines, and it can create lifetime divisiveness in the family, and that would be a dreadful, dreadful result. Who cares about money? The most important resource you have is your family and the love and trust that you all have, and when you destroy that, perhaps not intentionally, but that's the end result, it's a tragic outcome. So people should at least consider using an independent trustee before they decide to go down the path of having a child as a trustee.
Yeah, and the other
as
thing,
I say, I'm only 50% successful in convincing clients of this because they really want their kids as trustee.
Yeah, no, and I understand it, and interestingly, I've watched a lot of situations start pretty positive, and say they have you use Tom, Dick, and Harry. So let's say they name Tom, and Dick and Harry are fine with it at first, but then as time goes on, Dick and
Not
Harry
so
don't
much.
like what Tom is
Exactly.
doing. All of a sudden, they start fighting, and I've seen
Exactly.
multiple situations throughout my career where children actually stopped talking. And
Exactly.
it came down to, I'm thinking of several situations right now in my head, it came down to just fundamental disagreements on how to manage the trust.
Yep.
Frustration that maybe
Yep.
the trustee's not acting as a fiduciary.
Yep.
And it's hard. It's hard to remove yourself as a family member because you are. These are brothers or sisters of yours.
And you
it's
still
hard
got to
to
see
turn-
them at Thanksgiving.
You do, and it's hard to turn that off completely and then still act in a fiduciary capacity.
That's correct.
There's a lot of incentives at play, and it really can get complicated and messy, and I've seen this really tear up families before. Again, we're not making blanket recommendations here, but I don't think people consider the possibility that they don't have to name a child necessarily. They could actually name a professional trustee.
So where do you find one?
Well, that's a great question, Leslie. Tell me.
So institutions don't want you, or if they do, you don't want them because of the cost and investment returns, as I mentioned. So you have to then look at a category that I call pseudo-professional trustees. They're often attorneys, accountants, in theory financial planners, but I believe you have a conflict of interest, do you not?
I don't ever do it. I legally can't do it, and I wouldn't anyway. Even if I was asked, I wouldn't touch that.
And there are
because I'm trying to manage the money. I just want to manage the
Yep.
money. I don't want that other conflict in there.
So I'm a lawyer, and lawyers are allowed to do it, and some lawyers are willing and other lawyers are not. It's a choice that I was willing to do when I was actively doing that, but I also know that only certain trusts I'm good at and other trusts I'm not. And I have a sister who's a CPA, and she does it better than me, and so she's a paraprofessional trustee as well. So we formed a company, C&M Trust and Estates, and to allow the opportunity to provide professional trustee services to people that are willing to entertain it and it meets the right fit. And we also deal with the estate tax filings to do the portability elections and file any estate tax returns that are required. And so you have to search around to find a professional trustee, short of a bank or another institution, that would be willing to take it on. And those are hard to come by, which is why we have formed this company to try to fill this niche.
Yeah, this is a huge gap in the marketplace.
Yeah.
I think it's exciting that you've done something like this because, to my knowledge, there isn't really a lot of options on that in
That's
that niche. Which, is that true?
That is true. That's one of the reasons we opted to do it, because it's very hard to get appropriate skill to file the estate tax returns, and it's even harder to find professionals that are willing to serve as independent trustees with families.
Beautiful. Leslie, another great interview with you. Thanks for all this information. Do you have any final thoughts for us today?
It's really important to, as a individual person, to review your future medically, legally, financially every few years. I always like the first of the year as a time of reflection because, as you mentioned earlier, medically things can turn on a dime with no advance warning. Financially, as you well teach us, the markets will vary as to what kind of investing you should be doing. And legally, you need to have things in price. I'm working right now with my daughter and son-in-law. His parents are in Florida and are needing immediate Medicaid assistance to pay for the father's nursing home, and nothing has been done ahead of time. And Florida has special rules that we don't deal with up here, and how we have to address it. And because they're my family, I'm helping them, but it really requires running around at the last minute, and it's a terrible way to do it, and we might not be eligible because we didn't put pieces in place ahead of time. So periodically have a review with your whatever advisor you have on a regular basis. You should have financial and legal advisors. Meet with one or both of them on a periodic basis every 2 or 3 years. I think would be not too often. And the older you get, or the more precarious your health gets, the more frequently you should meet, so that you can look at, do you have the proper structure in place so that you can just turn it on if you need it, and are we ready to go if things are going to change, and we can still live our lives the way we want, hopefully help our families the way we want, but not create bigger problems by giving $18,000 away and then next year having a stroke and discovering we cannot qualify for Medicaid because we made that gift.
So do it while you're healthy.
Yes.
Do it while you're healthy.
Yep.
Leslie, thanks again for another great interview. Good to see you today.
Great hanging out with you, Drew. Talk soon.
We'll do it again.
Bye-bye.
If you've enjoyed this content and you're looking for a wealth advisor, or if you're a financial advisor and you're looking to make the jump to the independent side, please message me on LinkedIn, or you can email me at drew.benson@bensonwealthmgt.com, or lastly, you can call my office at 603-316-2544. Securities offered through Raymond James Financial Services, Inc., member FINRA SIPC. Investment advisory services are offered through Raymond James Financial Services Advisors, Inc. Benson Wealth Management and True North Wealth Management Group are not registered broker-dealers, and they are independent of Raymond James Financial Services. The foregoing information has been obtained from sources considered to be reliable, but we do not guarantee that it is accurate or complete. It is not a statement of all available data necessary for making an investment decision, and it does not constitute a recommendation. Any opinions are those of myself and not necessarily those of Raymond James. Expressions of opinion are as of this date and are subject to change without notice. There is no guarantee that these statements, opinions, or forecasts provided herein will prove to be correct. Investing involves risks, and you may incur a profit or loss regardless of strategy selected.